Hello everybody, welcome back to CLAT Tutor. I am Leher Jain, a third year student from the National Law School of India University, Bangalore, and I'm a part of CLAT Tutor's legal team. The news that we're going to be discussing today is the Supreme Court's decision on Reliance and Future Retail. This has been in the news, and this decision is considered to be landmark in the case of arbitrations in India. So, we will discuss what the dispute was about and what the Supreme Court held. To first understand the background of this case was heard by the Supreme Court through an SLP. An SLP is a special leave petition which an appellant is allowed to file against the orders which are otherwise considered to be non-appealable. So in very rare circumstances, through an SLP, the Supreme Court hears cases which are otherwise non-appealable. In the present case, there was a single judge bench of Justice R.F. Nariman, and there were two parties. The first was Amazon, who was the appellant or the person or the party who appealed the judgment from the High Court, and the second was Future Retail, who was the respondent in the present case. Now, this dispute actually goes way back. In August 2020, Future Retail is a company, and this company decided that it would sell its entire retail business to Reliance Retail. Now, there was an agreement between Amazon and Future Coupons, wherein Future Coupons is the promoter of Future Retail. So Amazon objected to its deal because Amazon argued that this deal would breach its contract with Future Coupons, or basically Future Retail. So there are two contracts in mind. The first is Amazon's contract with Future Coupons, and the second is the contract that Future Retail was supposed to enter into with Reliance Retail. Under this dispute, what then happens is that Amazon takes Future Retail to arbitration, and it initiates arbitration proceedings under the SIAC rules, or the Singapore International Arbitration Rules, against Future Retail. And while this arbitration is going on, there is an emergency arbitrator appointed. Now, an emergency arbitration is a special mechanism wherein the time taken to reach a decision by the arbitrator is very less compared to an actual arbitration. Now, this emergency arbitrator issued an immediate injunction which barred the parties from entering into the contract. So now, through this order of the emergency arbitrator, Future Retail and Reliance Retail would not be able to enter into their contract. In the present case, what then happens is that Future Retail is that Amazon comes to India because it wants to enforce this order or this award by the emergency arbitrator. And the Supreme Court formulates two major issues. The first is whether an award delivered by such an emergency arbitrator under the SIAC rules should be considered to be an order under Section 17 of the Act. And second is whether an order passed under Section 17 is in enforcement of the award, whether such an order is appealable or non-appealable. Let us look at Section 17 of the Arbitration Act. Section 17 reads and is related to interim measures by arbitral tribunals. If you guys would note that the emergency arbitrator's award was considered to be an interim measure. And it reads that a party may, during the arbitral proceedings, but before it is enforced, in accordance with Section 36, apply to the arbitral tribunal to enforce the same. Subject to the orders passed under a different section, these orders will be considered to be enforceable under the Civil Procedure Code because they will be deemed to be an order of the court. So what this section basically does is that it recognizes that an arbitral award is for all intents and purposes very similar to an order of the court when it comes to enforcement. Now, the major issue was whether an emergency arbitrator's award will be given the same recognition as a normal award under international arbitration. And the court held that it would. Amazon argued that the order was binding, and obviously, Future Retail argued that it was not. The court held that even an emergency award would be considered to be valid under the Indian Arbitration Act, especially under Section 17, and it would be deemed to be exactly like an order of an arbitral tribunal. So, in conclusion, this case was said to be won by Amazon, and it is considered to be landmark because emergency arbitrations are now recognized in India as well. Thank you so much for watching. Please write to us if you have any questions, and do leave your feedback in the comment section. Thank you.